Hello, I'm Sachiko Inoue, a Shiho-shoshi lawyer in Kobe, Japan. Shiho-shoshi lawyer handles inheritance matters. Today, I would like to talk about inheritance issues in international marriage. Inheritance is handled differently depending on when a Japanese spouse or a foreign national spouse dies. On this video, I would like to focus on when a Japanese spouse dies. When a Japanese spouse dies, Japan's civil code determines who is the legal heir, or are there any other legal heirs besides the surviving spouse? If the deceased Japanese spouse had children or not. If the deceased Japanese spouse had children, the children will become the legal heirs together with the surviving spouse. Not only your marriage with the Japanese spouse, but if the deceased Japanese spouse had children from a previous marriage, those children will also be legal heirs. Even if the deceased Japanese had children outside of the marriage, the children still be legal heirs as long as their paternity has been legally acknowledged. If a child dies before his or her Japanese father, any grandchildren or the child will become the legal heirs in the place of the deceased child. In this case, you as the surviving spouse will be entitled to half of the inheritance, and the remaining half will be equally divided amongst the children. For example, if you have 2 children, your legal inheritance share will be half, and 2 children will divide the remaining half into 2. So each gets quarter of share. So what happens when the deceased Japanese spouse had no children? You, as the foreign surviving spouse, and the parents of the deceased Japanese spouse will become the legal heirs. If the parents of the deceased Japanese spouse have already passed away, then any surviving grandparents will become the legal heirs along with the foreign surviving spouse. If there are living parents, you as the surviving spouse is entitled to a 2/3 inheritance share, and the parents-in-law are entitled to a 1/3 inheritance share, meaning that each parent is entitled to a 1/6 inheritance share. If there is only one living parent, then the parent is entitled to a 1/3 inheritance share. If there is no living parents or grandparents of the deceased Japanese spouse, his or her siblings will be the legal heirs. If the siblings have already passed away, then the children of the siblings will become the legal heirs, meaning even the deceased nieces and nephews can be the legal heirs together with you. In this case, legally, a 3/4 inheritance share to you, and the remaining 1/4 to your Japanese spouse's siblings or to their children. The inheritance procedures, such as changing registration of any real estate or closing bank accounts, should be done with other legal heirs. However, this is not the case if there is a will. Inheritance procedures can go smooth if there are good relationships between surviving spouse and children. However, the procedures can be difficult when there are communication difficulties between the people involved in the inheritance. I will talk about it in the next video, so I will say goodbye for now. Hope this information helps you for your fruitful life in Japan.